live, so now it's time to start drinking first. Yes.
Oh, Happy Bell Riots Day. You're a DS9 fan.
Yes.
Bell Riots started today, August 31st, 2024. So stay away from San Francisco.
Yeah, I was about to say. Yeah,
Otherwise, Ben Cisco is going to hold a shotgun.
yes. Are we sure they didn't start in Atlanta? It's Dragon Con. I'm just saying. All right. Good morning, everybody.
Good morning!
For those of you who don't know, we are at 10 o'clock on a Saturday morning at Dragon Con. People are going to be filing in very slowly because there was a lot going on last night. And for legal reasons, I will not go into any more details. Speaking of legal reasons, this is Legal Concerns While Podcasting. The idea is everybody's sitting down and pressing record lately. And we lived in an age where it used to be you could ask for forgiveness and that was better than permission. And that's not necessarily the case anymore. So I thought it'd be good to talk to some experts and just kind of see what's up with podcasting. I always wanted to do that joke. I'm Channing Sherman. I've been on the digital media track for a couple of years, moderating, being on panels. I host the relatively new Smarty Art Brother podcast. We just soft launched our first season last year. The next season will start after Dragon Con, thank goodness. I'm also a web professional, been working in digital media for, about 20 years now. I started when I was 2 years old. Okay, you guys did the math. Thank you. Thank you. So needless to say, I'm very interested in what we're about to learn today. And since I'm not a professional, we have two actual lawyers who are going to talk to us. But I think before we start, Meredith had a little something she wanted to get out of the way.
Just a general disclaimer that we're lawyers, but we're not your lawyers. Nothing that we say is legal advice. I don't even take clients, so I'm in the clear. I can't speak for Mitch, though. Mitch actually does litigate.
But not today.
Not today.
Don't give me a reason
Only in the court of public opinion today.
Don't give me a reason to litigate today.
Yes. This is just friendly advice. Think about that.
Yeah. Do you want to tell folks where you work, where you're from?
Absolutely.
Go for it,
Who the
yeah.
hell are you?
Yes. What makes you qualified to be up here?
I'm not sure I am, but I do work at the Electronic Frontier Foundation, a nonprofit legal organization based in San Francisco. We help ensure that digital technology supports freedom, justice, and innovation for all. I am the director of intellectual property litigation, so my beat is pretty much copyright, trademark, and all the ways that it is misused to suppress speech and control the internet. We represent clients. We also fight bad laws. We also build technology. And we are, if you'll forgive the shameless plug, supported by donations. So check us out at EFF.org.
Yeah, I'm Meredith Rose. She, her pronouns, for anybody curious. I work at a group called Public Knowledge. I'm senior policy counsel. Public Knowledge is a small, we're 25 people when we're fully staffed up, consumer advocacy organization based in DC. We are a combination think tank, lobbying, advocacy organization. We do not litigate, we don't take clients, but we work on a huge range of technology policies. Everything from net neutrality to antitrust to copyright policy to AI to ad tech, you name it. We are kind of magpies, and it occasionally becomes a problem. I'm the head of our IP policy portfolio, and a lot of that is because I am a nerd and I came up in fandom. A lot of that is me having to go up to Hill offices and explain how people on the internet actually work.
You're doing the Lord's work.
It's an uphill fight. Actually, the staffers are usually around my age. It's not uncommon to have staffers who are sort of millennial, older Gen Z at this point. So sometimes they get it, but their bosses are not always super keen on what's going on.
Yeah. Sometimes you gotta do a little translation, a little bridge building. All right. So before we kind of jump into it, just into the specifics, just when I'm sitting down and I'm getting ready to broadcast something or interview somebody, are there any things off the top of you? What are your red flags if somebody's like, hey, I want to start podcasting? What kind of red flags pop out for you from a legal side, if any?
So probably the biggest one would be using music or other recordings that you didn't make, which is always going to raise copyright concerns on some level. So you want to think those through when you're using any audio that you did produce. Probably useful to talk about some people's misconceptions about copyright. First thing is copyright is ubiquitous. Copyright applies anytime something is recorded on paper, to your hard drive, anytime something is creative material, that would be an audio, video, text, is set down in some permanent medium. Copyright applies. You don't have to register it. You don't have to apply for it, and that means whenever you're using audio that's not yours, or you can pretty much assume that it's copyrighted. It's less than 95 years old.
This is particular, and this includes like if you're reading text to do, if you're reading an excerpt from something. If you're obviously audio clips tend to be sort of like the more common thing that you run into in podcasts. I actually I have a short-lived podcast that's sort of defunct now, where it was called Ad Absurdum. Find it where get your fine podcasts. It was me and a friend of mine who's a criminal defense lawyer, and we would just watch terrible sci-fi movies or great sci-fi movies, and then we would lawyer them. So we did my favorite episode, and the one you should absolutely start with is we did one on Escape from New York, which was just chef's kiss. But part of that is we would quote the movie. And so we would quote lines. We had an opening that was a montage of a bunch of different famous clips from legal scenes in movies. And we had to do a lot of legwork about whether or not that would be okay. Now, this is the part where we address the elephant in the room, that is fair use. So fair use, the short version is that fair use doesn't mean what you think it means, and it usually doesn't mean what I think it means, and it doesn't really mean what anybody thinks it means. Nobody really agrees entirely. Fair use is, I'm not going to get into the law around it because that is literally an entire year of law school to get through it. But it is a multi-factor test. There are 4 factors, and if you're in front of a judge, which is the only time you're ever going to be able to argue about fair use, really, it only becomes important when you've been sued. The judge will basically kind of weigh the 4 different factors and ultimately just make a sniff test evaluation about whether they think it's okay or not, and off you go. Generally, you want to avoid relying on fair use unless it is something that is pretty clear cut. So something like criticism and commentary, something like an explicit parody of stuff that you're doing is considered a classic fair use. It'll help to think about the policy reasons behind why fair use exists, which is that copyright is fundamentally a restriction on speech. It is the restriction that if somebody else has made a creative work, the speech of anybody who comes after is restricted because they cannot duplicate that exact work. And so it is considered a kind of speech restriction. Now, the only way that works and jives with the First Amendment is if you have a safety valve on it. So things that we consider very important to society. So things like education, criticism, commentary. A lot of remix stuff gets in here, usually under the umbrella of criticism and commentary. Parody is considered a classic example of this. So you may have noticed, if you follow the news, was it Jimmy Kimmel who got sued by George Santos?
Yes.
Yeah. So George Santos,
God bless him.
internet character come to life. Was doing cameos, and the Jimmy Kimmel's writing staff got him to do a bunch of kind of goofy sounding cameos, about personas and all this wild stuff. And then they just took it and they played it on air to make him look very silly. And George Santos sued and basically said, no, when you got a cameo from me, there was a specific license attached saying you can do these things and not these other things. And you can't use commercially the videos that you're getting from this cameo, and broadcasting it on TV. Classic commercial use. It's something that almost never happens. It's got thrown out at the motion to dismiss stage, which is really early. A judge took basically kind of one look at the first or second round of briefings and was like, oh, this is definitely a fair use. Just chucked it. You're not going to get that lucky if you get into court. A lot of folks who follow copyright, myself included, like I'll take the L. I did not see that coming.
So you mean we can't just all go out and get the same lawyer that Jimmy Kimmel and NBC has? To get by
Sadly,
that?
no.
Okay.
Yeah, that's fair use. I don't want to turn this into a fair use panel.
We do have a fair use myth busting session later on.
All right,
to
then.
put it
All
out
right.
so we can
Save it
dive
for
into
that,
Yes, yes. But you also bring up something. You mentioned Cameo. You've got all these new services and platforms and ways to distribute information. And laws have to, I won't necessarily say change, but I'm sure they kind of have to adapt to some of this thing. Is that something EFF has kind of been looking at, how this stuff is going to be litigated going forward, how it could be litigated?
Oh, absolutely. In fact, we have a case right now. We're trying to get a copyright suit thrown out at that that very early stage. But these things happen in the courts, right? The actual fair use law is, it's just half a page long. It's not a lot of law. It's the courts that fill in all the details. So the change happens incrementally, without previewing the fair use panel too much. I will add a couple of things. There is the biggest myth about fair use is that there are safe harbors. You can use 30 seconds of something. You can use 10 seconds of something. You can use 8 seconds of something. There is no safe harbor. There is no firm line below which you are perfectly safe in using something. But that's true of life, right? Because anybody can sue anybody for anything. There is nothing you can there's nothing you can really do, especially when you're putting media out in the world, to completely avoid being sued by somebody. It's just a question of how much risk you want to take on, and the bag of things that affect your risk when you want to make fair use of something. And then again, this is not legal advice. This is my big picture on
This is your friend Mike
Yes.
just talking.
Yeah.
Yes.
But one Meredith mentioned is it commercial? That's not the end of the story. You can be a commercial podcast, you can be an ad supported podcast and still use fair use. You're not disqualified from it. But being not for profit does, or a hobby, does reduce your risk. Of course, the length of what you take changes your risk. Using an entire song is pretty hard to justify. Not impossible. There are cases when that happens, but it's harder. Whether you're parodying, commenting on, criticizing the thing itself, the thing that you've copied, that's really pretty safe ground if you're doing that. But like Meredith said, and then the last one is if you're changing it. The lawyer term is transformation, or it's if you're taking something and really making something new out of it, so that maybe you can sort of recognize what the original was, but sort of your average non-legal person would say you've taken it and made something different. That's also a risk reducing move.
Yeah, that's actually good to know. I want to circle back around the copyright for a minute. One thing about podcasts, we love our punny names, our fun names. A lot of times you hear people say, "Oh, you've got that name. You need to go get it copywritten. You need to go get it trademarked." Do they need to do one, the other, both? Does it matter? Should I be running to the patent office, not the trademark office here to get Smarty Art Brother locked down when I leave?
It's actually the same office.
Oh, there you go.
U.S. Patent and Trademark Office.
There you go.
Yeah, so you can't copyright short phrases. So business names, podcast names, that's a trademark question. One thing to keep in mind is you have to actually be using the name in commerce. You can't just say, like, I got a good turn of phrase here and I'm going to squat on it. So if anybody else is like chronically on TikTok, like very demure, very mindful, the meme that's going around right now, the woman who actually coined that got beaten to the trademark office. Somebody else managed to trademark very demure, very mindful. And to do that though, you have to prove you're using it in commerce. So you have to come up with like merch, basically. Hawk Twa Girl, that's been trademarked.
Yeah.
There's merch now. God help us.
I don't want to know what kind of merch that is.
Honestly, get that bag. Like, good for her. But yeah, so there's kind of one thing to think about is there's two different buckets here, trademark and copyright, and they get confused a lot. to the understandable chagrin of a lot of IP lawyers. Trademark you can think of trademark as almost like a kind of consumer protection law.
That's what it's supposed to be anyway.
That is what
Yeah.
it's supposed to be in theory. The idea behind trademark is that if I, as a consumer, walk up to something and I see a familiar symbol or I see a name of a company, that indicates to me who made that thing. So that I know every time I see a pair of golden arches on the highway, that I know I'm going to be able to go in and get the same thing that I always get at the golden arches. Like, it's going to be consistent across golden arches. If I see, here's the controversial example. If I see the Mickey Mouse ears, now it gets a little bit weird because Steamboat Willie's in the public domain. But if I see the Mickey Mouse ears, I know that Disney has signed off on whatever product that is. And so that's the idea behind trademark. Copyright comes from this idea. So copyright protects creative works, like in their totality. So it's like a whole. So you could copyright an episode of a podcast, but you couldn't copyright the name of it, if that makes sense. And copyright, there's like a bunch of actually kind of competing underlying theories as to why we have copyright. But like historically, the American idea of copyright comes from this idea of like creating an economic incentive. It's this idea that like making a creative work takes a lot of time, takes a lot of effort. And when that gets let out into the world, we have all this technology right now. And copyright actually dates back to like the proliferation of the printing press. So, even back then, if you let a book out into the world, you would have these rogue printers, mostly in the Netherlands at the time, who would just make pirated copies of stuff. And they're just like, sweet, here's a book, much slower because it was printing, sort of in Gutenberg speed. But they would make tons of copies of it. And the author then couldn't recoup the money that they forwent by not doing other work when they were making this creative work. And so this idea of like, well, we need to like give you a period where you're the only person who can monetize this to recoup the money is exchanged for the effort and time that went into making this in the first place. Now that's the theory. The actual use has like become some huge monstrosity entirely. But that's the idea. If you want to so if you would copyright a podcast episode, technically it's copyrighted when it exists. Like if you've finished editing it, boom, it's, even if you haven't released it yet, it's technically copyrighted. But if you want to protect the use of the name that you're using for your podcast, like if I really wanted to make sure there was not a second ad absurdum podcast, which too late there already is. It's a philosophy podcast that I've never listened to. Then I would go to the trademark office and say, I'd apply for the phrase ad absurdum for use in connection with the specific kind of thing that I'm doing. So for use in connection with podcasts.
So all those people online who are saying go out and copyright everything, they're just kind of, okay. Not necessarily the best.
Well, that's what I mentioned. I mentioned the copyright is automatic. Trademark, to a degree, is also automatic. If you have a business and it has a name, whether that business is a podcast or anything else, and somebody else comes along and start using it, there are ways you can take them to court. Now, those ways become more potent, and particularly more. You get more of a geographical advantage if you go to the trademark office and register a trademark.
Yeah, because I think there's one. Is it Burger King? There's one non-Burger King that just incidentally was operating before the big Burger King brand existed. It's like in Indiana somewhere. It's like somewhere in the Midwest. There's just one Burger King that is not the Burger King that you all think of, because they just existed first. And so they're like, we've got like a little fief where we're the Burger King.
Yeah.
And they can't get sued for it because they were there first.
Yeah, I used to live in Charleston, and there was a little odds and ends antique store called Trader Joe's. And there's actually a Trader Joe's just like one city over, actual Trader Joe's proper, and somehow they are just getting along in perfect harmony, probably because they are two. And I never heard of Trader Joe's. People are like, oh, I went to Trader Joe's and got this really great cinnamon spread. I'm like, it's an antique store. What, buying antique cinnamon spread?
Got my tikka masala from the antique store.
Right, exactly. I was very confused. So yeah, I guess there's something to the whole having the name early thing. Let's talk content ownership. I think of it in two ways. One, you have a lot of people, they're joining podcast networks now, and there's usually requirements sometimes in the fine print about who owns that content and how much content it need to produce. But I've also personally seen podcasts that maybe have 2 or 3 hosts. There's a falling out between them, and then it, who owns this, who owns that. How do you try to prevent that before it even happens, or is there a way?
These joint authorship situations are pretty sticky, can be pretty sticky legal conundrum. So the best way to do it, as with a lot of things, is make an agreement in advance as to who's going to own what. If you do that, that's probably what's going to control. If it's if it's a group effort if it's and write it down. Yeah, if it's a group effort, if you're all contributing to it, and if there's no clear way to separate or my contributions and your contributions, you're going to own, then chances are you're going to own it jointly. And that means, should you go your separate ways, anyone can use it, anyone can license it, sell it, make money from it. That is hard to unwind if you don't have it, if you didn't have it in writing.
This is actually so this is the part where we always say, like, if you are seriously considering doing this, write down your agreement. It just somewhere, like, for the love of God, write it down. You do not want to be arguing about this 10 years down the road based entirely off your memories. That's a recipe for a nightmare. Talk to a lawyer. There's like a ton of lawyers in this space right now who work with like small streamers, who will work with podcasters, who are like very familiar with this space, who do very, very low cost consults. Like, you want to get a lawyer before the worst day of your life, basically. Yeah, and the other thing is,
consider it like a prenup.
Exactly. And if your friendship could not survive writing it down, maybe don't go into business with them.
Nothing wrong with working solo.
Yeah, and the other thing is, like, anybody in the video game preservation space, I don't know if anyone here is like a big like retro gamer, but yeah, I work with a lot of video game preservationists and archivists, and one of the biggest contributors to vaporware is that they have these tiny studios that are like 5 guys. Used to be like working out of a garage. Nowadays, it's you're working on a Discord server, who never wrote anything down, went their separate ways. Nobody knows who owns it anymore. And it's just gone poof, and there's no legal, you can't get through the legal thicket of figuring out how to copy it or license it or use it or anything like that. So don't be that guy.
And not to invoke the doom part of this, but the potential damages and copyright are high enough to be, you're playing financial Russian roulette.
Yeah, $150,000 statutory damages per
maximum. I mean, they don't always go that high. That's the ceiling.
But still,
it's a lot.
Yeah. I mean, look, most of us in here, I would imagine, we're all poor. So for me, $150 in damages. Yeah, I'm missing groceries or something.
Mm-hmm.
You kind of briefly touched in on my other one. I was going to ask about agreements. You always hear people say, "Oh, we had a verbal agreement when we started." How strong are verbal agreements?
Don't do it. This is me Muppet shaking my head. Don't write it down, for the love of God. Like, preferably like a PDF that can't be edited or something. Like,
right.
Just write it down, please. Save everybody the headache.
There you go. If you take nothing else away from this, write it down. There you go.
If you don't write it down, the best case is a really expensive lawsuit to figure out who said what.
Okay. Avoid expensive
And
lawsuits.
also, you don't want your Discord subpoenaed for evidence. Like, never get the group chat subpoenaed ever.
Wait, they can do that?
Oh, yeah.
I got to go delete some stuff. I'll be right back. So we're going to circle back around to our favorite subject, fair use. We kind of already discussed what it means and kind of what you can and can't do, but I thought we'd do a little bit of fact versus fiction. And some of these are actual things that I've heard people say about fair use on their podcasts.
Oh, no.
Yes. As long as I don't stand to make money from it, it's okay. That's fair use. So I can play that Beyonce song while I'm streaming.
Nope.
No.
Nope.
Well, but not making money does move you in the risk reducing direction. But it doesn't get you. It doesn't eliminate the risk.
So you still get shot. You just maybe get shot in the arm.
Yeah, exactly.
So yeah, okay.
Not in the head.
Yeah, okay. It's
You
a little bit better.
You might win that expensive lawsuit. It might be a bit of a Pyrrhic victory.
God, I don't want to be sued by Beyonce's lawyers.
You just know they're the most fabulous lawyers.
Put that on my tombstone. Got sued by Beyonce.
Oh, this is one of my personal favorites. adding no copyright infringement intended
Oh my
in the
God.
caption is enough to avoid a legal issue.
No, if anything, that might be waving a red cape at a bull.
I grew up on fanfiction.net. I am very familiar with these disclaimers.
Yeah.
They mean nothing. No. If I have actually, hand to God, I have joked semi-seriously about getting a second tattoo that reads no copyright infringement intended. It doesn't mean whether you intend to infringe or not. It doesn't mean anything. Either you did or you didn't. A court is going to get to decide that, and saying I don't intend to infringe copyright is not going to do you any favors.
Yeah. Using my earlier example, I didn't intend to shoot you, but I shot you.
Yep.
That's not going to hold up in a court of law.
Yeah, and if there's a copyright holder out there who's really intent on taking people to court, they probably have a lawyer doing a search on that phrase.
Yes.
I get the same tattoo.
Honestly, it would probably be infringing on all of the like AO3 authors who have put that in their author's notes. So come at me. Like,
I think there's one over there.
This is my page. I do not give permission to Facebook that
doesn't mean anything.
Yes. Please stop doing that, because I have a lot of friends who do that.
So any mainstream platform has more or less the same language in its terms of service. Those terms control over whatever you write on your on your page, and those terms say you still own your stuff, but we get to do anything we want with it.
So you still own it technically.
Yeah. And
but just try and stop us.
right. And for those of y'all listening who missed the question, it was about those wonderful posts that your friends do once a year, denying Facebook the permission to use their information that they've already given Facebook permission to use. When your aunt posts that, after a few glasses of wine, you can tell her that does not help at all. Those family reunion pictures can be used against her. Just throwing it out there.
Maybe they should.
That's a different path.
I'll tell you, many of us went into law school thinking that law was a series of magical incantations that would change reality. We were all sadly disillusioned. It is depressingly practical.
Yeah, that's a sovereign citizen.
Yeah.
I'll briefly segue. I was on an EFF panel a couple of years ago, and I spoke on something using the legal knowledge that I learned in high school, maybe first year of college. And I don't remember the guy's name, but he worked for EFF too. And he was like, no, that is completely wrong. And I'm thinking, oh, everything I learned in school was a lie. It wasn't that. It wasn't the complete truth. It was the whole First Amendment protects you from shouting fire. No, doesn't protect you from shouting fire in the theater. Yeah, the crowded room. Yeah. Everything you learned about that in school, wrong apparently.
Yeah, that was a terrible opinion justifying throwing somebody in jail for resisting the draft.
Yeah. Weirdest thing ever.
Don't quote that one.
Yeah.
Actually, if you Google Ken White Fire in a Crowded Theater, there's a wonderful blog post by a blogger named Popat who goes into all of the reasons nobody should ever use that analogy ever again.
Yes. Yeah. And you could. He wasn't upset with me for saying it, but you could see the look
so
on his
obvious.
face where, he's like, oh, not this again. It was quite interesting. Let me see if I can put this fire out beforehand. Crediting the content creator protects you from liability. So again, if I'm using that Beyonce song, I say, hey, playing my favorite Beyonce song while I'm playing this game, Beyonce is gonna be cool with it.
But copyright itself doesn't care about credit. Copyright and plagiarism, two different things. And whether you give credit or not has no bearing at all on copyright. One exception to that if you're using something like a Creative Commons licensed work, because those licenses say, I give you permission to use my copyrighted work, provided that you give me credit. In that case, credit matters quite a bit. If you're in a Creative Commons situation, Creative Commons is a wonderful tool. There's a wealth of content out there that's Creative Commons licensed, and you are free to use it as long as you give credit in the right way.
Now, this is one of my favorite ones because some people see it as a technical rule, other people see it as a legal rule. As long as you only use X amount of seconds of the music, it either A, counts as fair use, or B, the algorithms that detect it can't pick it up because you haven't played the entire song. So it's like, oh, I'm only going to play the first 3 seconds, and that counts.
No.
I love it so flat. Nope.
Doesn't matter.
There's no safe duration.
Nope.
The algorithms, I don't know. They change.
Right.
The algorithms are hilariously bad in all kinds of directions at
Mhm.
their job. So kind of famously, back in the early pandemic, there was I'm talking like first 3 or 4 months, a lot of performance musicians, like especially classical musicians, would start streaming live performances of them playing classical music. Now, the classical music that they were playing is very old and it's in the public domain. Okay, so they're like, there's clearly, and I'm playing it for myself. This is not an existing recording. I am totally in the clear. Let's go. They were getting flagged and taken down in real time because, fun fact, a lot of classical pieces, like different versions of them, all sound very, very close to each other. And so it was flagging them as existing copyrighted recordings
Mhm.
of classical pieces. So they're very bad at that. Somebody once got okay, it may have been a meme, and if it is, I apologize, but I do remember seeing a screen cap of somebody getting a copyright notice for John Cage's 433. Wow. Which, if you're not familiar, is just 4 minutes and 33 seconds of silence.
Mm.
So, yeah.
At certain major music publishers, Sony Music, would happily collect a $500 licensing fee on those classical music recordings that nobody copied.
Yeah. I may need to fact check, but I feel like there was an incident with Metallica. They were playing, and it was an event that was being streamed on Twitch.
Mhm.
They were playing their own song.
And it got flagged by
It
the
got
label.
flagged,
Yeah.
live, and I think it went out. They replaced it with their generic music as they were playing it.
Yeah, which was ironic because Metallica were pioneers of copyright enforcement on the
Yes.
internet.
Lawsuit.
Exactly,
It kicked off the Napster lawsuit era.
exactly. It was karma coming back around.
The irony. It's so delicious.
I think their stream was interrupted.
Yeah.
In real time. Yeah.
Yeah, how did nobody at Twitch think about that one? Yeah, guys, what? Nah, they were just in a rush. Okay, last one. This is again one of my other favorites. When I pull something from the internet, it's automatically considered public domain. Because obviously, if it's on the
God,
internet,
no. If you're pulling from something from the internet, it's almost like 100% guaranteed to be copyrighted by somebody. So this is a good point to talk about legal exposure versus practical exposure. These are
Yeah.
two very different things. Legal exposure is, if you're in a courtroom, what is your risk of being on the hook for copyright infringement, which is, again, about 90% of the stuff you got to worry about in these. And then there's practical exposure, which is what is the likelihood that you're going to get dragged into that courtroom in the first place? And that is a more wobbly calculus, but it is also one that you, as a content creator, are better poised to assess because, especially if you know anything about the content that you're planning on using. So there are entire communities where there is an understanding. So this is like, I have a whole sort of side project about folk copyright and like how online communities understand like their own sort of quasi-legal intellectual property regimes. And a lot of them are things like, as long as you attribute to me and are not making any money off of it, go nuts. And that's fine. That's a folk copyright situation though. And so in situations like that, if you know for a fact or have a pretty good idea, like this is somebody who puts their stuff out online and like they've been really happy or they'll retweet, when other people remix their stuff, like they're generally very pro. Like if you know that, you've got a much lower practical exposure probably. But again, it's practical versus legal exposure are two different things. And legal exposure, you need a lawyer to make that calculus. Practical exposure is an assessment you can make on your own.
lessons learned.
Yeah.
Okay. So we're all going to get to the Q&A in a few minutes, so you guys can start, thinking of some good ones. I did want to. This one's a little bit touchy, I think, but I am curious about. You mentioned that people should hire a lawyer or get legal help if they have questions. Again, I'm going off some knowledge that I've heard from people themselves. A lot of these online services, their name rhymes with things like Schmiegelmoon and places like that.
It took me a second. I was like,
Pocket Lawyer, that's another one. That's what it rhymes with. If I had to choose between using those because I'm just getting started and I'm trying to save a buck, or those places, I don't want to have you up here trashing them, but is it something you'd recommend? Let's put it like that.
not on copyright. I probably maybe on some other legal questions, but not on copyright. Copyright's pretty specialized. Honestly, what I would recommend is call up the law schools in your area and see if they have an arts clinic or an IP clinic. When you have a choice, always ask students because they studied the material yesterday and they have an experienced professor backing them up, and they don't charge.
And honestly, there are, so like, I know Noah Downs was scheduled to be on this panel originally. He's like a great example of, again, there's a whole cottage industry of folks who work with podcasters and Twitch streamers and will very happily take phone calls. Some of them will do like free baseline consults. A lot of them is like, pay what you can kind of situations. Especially if it's really basic stuff like, and even you can ask them like, can I just pull a contract from LegalZoom to, say like, you've done this part of the podcast and I've done this part of the podcast and that's how we're assigning responsibility. Like there are resources out there, and frankly, just like DMing folks is like a pretty good place to start. Question mark.
I mean,
Yeah, just
which
don't
one
take
would-
it if they're giving it to you in public.
Right,
Yeah.
right.
And don't ask about trees.
Oh dear Lord, no! I've actually seen. I think a couple of those posts you're talking about. Yeah, tree law is very. Also, tree care. People are very interested in that. And I'll just throw another one out there. I'm from Louisiana originally, good and bad with that statement. But there's something there. They do lawyer months, and local libraries will invite lawyers in, and they'll just kind of answer reasonable questions, free for like an hour, or they'll do panels on specific things. So yeah. So check with your local library, learning annexes. There may be some options there also. For people who are looking to hire an attorney, and a lot of these attorneys, they're going to list 50 million specialties. They may have a bunch of different things after their names. What should they look for to make sure that they're getting the right attorney for them? I specialize in XYZ.
Specialties are hard to assess and not really firmly defined in law. The most, yeah,
If they say I work with podcasters, you're gold.
yeah. But the main thing I think is personal comfort. Have a conversation with the lawyer. Are they listening? Are they listening to you? Are they respecting where you're coming from? That's more important than whatever they claim is their specialty.
Very good. Very good.
I do have one thing because I work a lot on music law, and it would be I would not say malpractice because again, none of y'all are my clients. A very important thing to keep in mind about music copyright. So when we talk about clearing licenses for things, the thing that trips people up the most is music, partly because there's a lot of music sampling that goes on in podcasts, and partly because music copyright is its own special complicated nonsense. For reasons that only really make sense historically, but we're stuck dealing with them today. Any given recording of music actually has two copyright owners attached to it. There is a copyright in the underlying composition of the work, so the thing that the songwriter output, and then there's a separate recording or a separate copyright in the recording of it. Those are two different owners. If anybody here is familiar with Bittersweet Symphony by the Verve, that sampled a Rolling Stones track. So that opening orchestral bit in the beginning was originally a part of a Rolling Stones song. They went and cleared it with the label that owned the rights to the recording. They never went and cleared it with the composer. And so they got dragged into court, and they continued until very recently, until like the last 5 or 10 years, had to pay all royalties from that song to Mick Jagger, who was the songwriter. And so like, if you ask the lead singer of the Verve, has a great line about this is the best song that Mick Jagger never wrote. And yeah, so be very careful. If you're going to clear a piece of music, make sure that you don't stop at reaching out to the record label. Depending on your use, you may either have to go to the music publisher, you may have to go to performing rights organization, which is like ASCAP, BMI, there's a whole bunch of them. And so just don't do the easy thing and just like call up the record label and hash out a deal with them. Make sure you also figure out who's got the composition rights.
Again,
Trips up so many people.
yes. Don't make Beyonce mad. It always comes back. Yes.
Or Mick Jagger.
Oh yeah, well, especially Mick Jagger apparently. Anybody who has a question, you can go ahead and come up to the mic for us. And looks like you get to be
Just come
first
on
right there in front of you.
Hello.
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 Howdy.
I actually have a few questions, but I'm just gonna start with one. I actually have I'm working on a murder mystery podcast. I can probably tell from the shirt.
So it says tarot killer for anybody who can't see.
Yes. So I work with it's a radio drama. So I have voice actors, and I actually hired a musician to work on the music, and I have a friend who is an artist who's doing the merch. In order to try to keep things as legal as possible, I kind of made like a contract to like things that thank you. And it's yeah, thanks. I even checked out like other contracts, how they're written, and I just all the basic stuff, like I'm not going to use your stuff for AI, that it's just for this project and blah blah blah. But I have some people that I commission, or some voice actors that were like, well, I'm gonna have to hire a lawyer before I sign this, and you would have to pay extra for that lawyer, and then they don't want to sign the contract. Does it matter if they sign the contract or not if I hire them or commission them from like another resource like Voice123 or Twitter or something like that already kind of has an underlying contract for commissions, or am I overdoing it?
I don't know. So I will say Twitter. Don't rely on Twitter for anything ever. For things like Voice123, which I'm assuming has a setup kind of like Cameo, usually those kinds of like gig work platforms will have some kind of default license attached to hiring somebody. Now, I don't know what's in the default license, but most of the time when you hire someone through like Fiverr or whatever, there will be some kind of contract that goes along with that. I think making your own contract is actually like a really good instinct on this, especially now that we've got, you can be more responsive to things that people are worried about, like using it for AI training. And that's good. Like you can do that, and places like Fiverr or Voice123 may be going entirely the other way. Having said that, I don't know what is in those default contracts.
Yeah, I think your instincts are right. You are ahead of most people on this. I would, if someone is really insistent, or then I would think hard about what that means for your future working relationship.
Yeah, I get it though. I get like if they are going to have to hire, and it's frankly good on them for thinking like I should have a lawyer look at something before I sign it. Like
Yes.
Correct instinct.
Yes.
If
we had a cookie, I'd give it to you. Yeah.
And likewise, if you wanted to take your contract to a lawyer to give it a scan or a legal clinic, that's both a good idea and probably not expensive.
Yeah. So like this is a rare story in which everyone is behaving rationally and in the way that we would all like them to. So
It's an internet miracle.
Thank you for boosting my spirits today.
Anybody else?
Oh,
Oh,
y'all
wow.
can just like line up.
Yeah. You can laugh. Yeah.
Go nuts.
So I'm looking at starting a podcast next year, and I'm sort of preparing for it. And you just convinced me to trademark the name. So if I do that, am I trademarking just the name, or if I have like associated iconography, is that also part of the trademark?
Either or both.
Okay. And what if I were to change my iconography like 3 years later? Would I
You
have
could
to
register.
trademark
You
it?
could register a new trademark.
So I have to do a new trademark.
Yep.
Yeah.
Okay.
It's a new application. It's just a form and fees.
Okay. Cool.
I've had a copyright strike on myself before. It's very complicated and confusing trying to tell yourself that you are the person that is. I've never figured out how to do it. Anyway, the question is, I'm from the UK, and I'm curious about the way rights and usages and things work across the world, and how basically where am I likely to get sued?
That's got to be America. That's got to be America. You can't tell me it's not.
And any sort of general things on that. It's quite an open question.
Yeah, please.
So I mean, Americans statistically are likely to get sued for anything. I feel like more than most places. Having said that, like American fair use jurisprudence is like a lot more robust than you'd find pretty much anywhere else in the world. To the point where like there were South Africa was actually thinking about introducing like an American style fair use provision in their copyright law, and it like almost got them on the trade blacklist at the U.S. Trade Representative.
because
the
of the
content
because of the major music labels came in
They
and
were
said
so
and said,
mad.
"Don't you dare use American style fair use."
just big mad. And Canada's also got a thing called fair dealing, which is like very similar. Actually, the place I feel like where it ends up being really, because of the systems end up being kind of different, are places like France. France is a very, very strict protective of creators, is the way that they think of it, copyright law. And there are some exceptions and limitations that they're legally required to include because of like EU treaties, but they do it begrudgingly. So I would be, if I had to like make a power ranking of place where you're most likely to get sued, I'd probably put France near the top. The US right under it, just because we love to sue people. And this is where most of the big rights holders are based. And then towards the bottom, you get probably like Canada-ish.
But we're still in the top 3, so go USA.
When you're talking about when we talk about the norms and the practices of platforms like YouTube, obviously that's based in the U.S. The U.S. law sort of sets the global norms on those. So for things like the copyright strikes and takedowns, sort of operate in the U.S. fashion. It doesn't mean you won't get sued in France, but if you don't have any assets in France, it probably then you don't have any assets across the channel, it probably won't matter.
Yeah. Well, there's also the related question of where you're most likely to get taken down, which is like a different calculus, and that's places like China, Iran, any place with kind of a large firewall filter situation. The UAE's got a lot of
Russia.
restrictions on Russia. Yeah.
Thank you.
All the people who are very fun and cool with free expression.
Exactly.
So I have two kind of like clarifying questions and then a real question. And the clarifying questions are like, so if I understood correctly, when you were talking about using music and stuff in podcasts or like maybe a short clip of something, there is no safe time of like 3 minutes is fine or like
There's
whatever.
no magic number.
There's no
Okay.
magic
No
number.
magic number.
And then other clarifying question, if I had a cool name and somebody else had that same cool name, but it was for a different thing, would that still work? And it would
Yeah.
be okay?
Yeah.
Okay.
Yeah,
it would
there's
just be like,
no
you stay over
there's
there
no
and I
problem
stay
with
over
there's
here.
Delta Airlines, Delta Faucets, Delta Dental.
Okay.
They can all coexist.
Perfect. And now to the question, how do I as an artist protect my art? Because signatures like can be, taken off of things or put onto things and stuff like that. And so what's my best way if I want to protect my art
And
to
you're
keep it safe?
And you're specifically talking about visual art.
Yes.
Visual- okay.
There are a few things. Be clear with what you do and don't want people to do with it. Use plain language. Put it on your website. Put it wherever you display your art. Consider registering your copyrights. That's also just a form and a fee. It's again, copyright is automatic. You don't have to register it to be protected, but it does give you some benefits if you ever want to try to enforce your rights in court.
There is also now we have a thing called the Copyright Claims Board, the CCB. Mitch and I are making faces. So there is a copyright small claims court that exists now. It is based within the Copyright Office. It's been out for about 2 years now. It's had some mixed success, but the idea behind it is that it is a much simpler, lower cost, lower stakes forum that individual artists can access to either get somebody to mostly to pay damages. So like the DMCA takedown notice is always going to be your first line of defense on these things. But especially, I know it's a common problem for visual artists to see your stuff pop up in like Redbubble t-shirts, like, classic issue. If you can't get people to stop doing it, you can go to the Copyright Claims Board. Now, it's a little bit of a slog. Some of these things do take time to resolve, but the idea is you don't have to go to federal court. So you don't have to go through all of the litigation expenses of a traditional lawsuit. You can get up to, I think, $15,000 in damages. And it's supposed to be a more streamlined, easier way to do it. So
And
look
in
into that.
theory, you don't need a lawyer.
In theory, you don't need a lawyer. If you file a complaint and you file it wrong, the Copyright Office will actually come back, review it, and come back to you and say, like, here's what you missed. So if you're finding stuff that is just intractably popping up, I would consider looking them up.
Also, it might be a whole other panel, but can I get in trouble for fan art?
That's a practical exposure question.
Yeah.
Characters do have their own copyright, which follows them around, which my head will explode if I think about it too much. And I will be here all day ranting with Mitch. But you're probably fine, because the reality is that most major rights holders nowadays recognize fan activity for what it is, which is a huge engagement driver, and ultimately a huge profit driver. So don't sell it. Is generally a good idea.
We're down to the 10-minute mark, so Keaton.
I was hoping that you guys could briefly talk about some of the pitfalls with using supposedly royalty-free music.
Very little. It's quite safe. Read the fine print. You know. But there's lots of high quality sources of royalty free music. They may want you to give credit. You know, be sure you respect that.
Yeah, just read the fine print.
Yeah.
Right. So I started a parenting podcast about last month. We've not done too much legal stuff because it's a hobby, not trying to make any money out of it. How important is it to trademark that name and image that we had created if we're just doing it for fun? Like, do we need to
No.
get it done
No.
just in case?
We don't. I think we ever trademarked ad absurdum or any podcast that I was involved in, because it was just we're just doing it for funsies. If somebody makes another one with the same title.
Okay, yeah, because we called it Dads Discuss, and it's like that people use that phrase all the time.
Yeah.
So
That'd
it's like-
be a difficult phrase to get a trademark on.
Yeah,
anyway, because it
exactly.
describes what it's a description of what you're talking about.
Okay,
Yeah.
sweet. Thanks.
Yes. Look, podcasting started out as a way for people to have fun. So yeah, you're doing it like that. Go for it.
So I joined a podcast that has a history in the last few years, just as a fun thing. So for me, it's fun. For them, it may be a monetary thing in the future, and I don't really want to make money on it. I don't care. It's just fun for me. How enforceable, or if I wanted to put something in a contract with them to say, hey, you make money, it's your podcast, whatever, but if I ever leave, the stipulations of how you use my likeness or how you use my voice, you can't like change it to make fun of me or portray me in a negative light. Are those as enforceable as the monetary aspects of contracts, or how does that work?
Yes.
Yeah.
That made I'm sorry, just like the concept of like remixing your voice to make you be like
Yeah,
on a
so-
podcast.
Right. Yeah.
It's just
I don't know.
very funny to me.
And those are also standard things you kind of see in some contracts as well. All right.
Yeah.
You might want to have a lawyer write it.
Right.
Yeah, don't let your podcast go the way of Bodega Boys and disappear.
Yeah, that was ugly.
I'm still hurting from that one.
Not quite 5 minutes, but I brought it just in case. Part of a show that was under a media entity for 10 years, they dropped us. We decided to go indie. First thing we did, build an LLC partnership. We got that all kind of squared away. But we're talking about trademark and copyright. We realized like we created logos, we created the name and all of that in the LLC. But is trademark separate from that? So if someone were to trademark it, how does that work with
it is.
that? Okay, so that's a whole separate process.
The U.S. Patent and Trademark Office.
Excellent.
Yep.
So
Go look them up.
hey Seth, we should probably do that.
Yeah,
Lesson
it would
learned.
be in some forms. You can get a lawyer to help shepherd it through, but unless you're looking at a situation like you're trying to do something like Dads Discuss, or a more complicated kind of application, then, or heaven forfend, if you tried to name your podcast Blue Ivy, they trademarked their kid's name. There was a whole big fight about it actually, because there was an existing Blue Ivy business. I don't remember what they did, but don't name your podcast after Beyonce's kids. But yeah, I mean, you can do it. It's designed to be relatively, it's still the federal government, so it's still going to take a long time.
Yeah.
But,
Not, LLC paperwork was enough, but hey, we can keep doing it.
Yeah.
Thanks.
And
As you
again,
talk,
you are protected even while that process plays out.
Yeah.
okay,
Yeah.
fantastic. Thank you.
All right. So you got one. Make it quick.
Is there just another kind of clarifier? So is there a way? So as you can see, I have this is Tarot Killer again. I have a trademark, sort of like a logo, but I also know that there's a book named Tarot Killer, so I don't want to like trademark the name, but like the logo itself to keep people from like making botched merchandise or something like that.
I mean, you could probably trademark the name too. The complication is if the person who owns the book comes in and objects, and says like there's a likelihood of confusion. That's like the big.
Yeah. Like I don't like it's two completely different
Yeah.
like
But
things.
the logo for sure.
Yeah.
Yeah, the
Yeah,
logo.
yeah.
Logo, absolutely.
Okay, and that's a trademark. Oh, yeah.
Yep.
Okay.
You can. I mean, you can also copyright it because it's visual art. So
Oh, okay. So maybe both. Well, I
Yeah.
guess it's already copywritten. If it's a
yeah, you can register it at the Copyright Office,
Yeah.
which again gets you access to the federal courts. It gets you bigger damages. It makes it a little more credible if you send a stop doing that letter.
okay.
All right. So before we wrap things up, I'm going to give you two the opportunity to kind of shoot your shot. One, like I said before, I'm not an expert at any of this. So in the next couple of minutes, if there's anything you feel that I missed that you want to let people know about, and also if people maybe want to follow up with you after this, how they can find you, or if you decide to bring your podcast back, how they can go back and hear it. You want to start, Mary?
Yeah. So, I mean, I think this is great. I think we're at a point where we're seeing podcasts transition from a hobby into like an actual industry, which is great because there's room for all versions of this. There's room for hobbyist podcasts. There's room for people who make their living off of it. If you foresee yourself doing this as anything more than a very casual hobby, talk to a lawyer, please. Because again, if I want you to take away anything from this, it's that you really don't want to end up in a court doing a he said, she said fight 10 years down the line. You super duper do that. Yeah, go forth and podcast. Go forth and listen to Ad Absurdum. And start with the episode on Escape from New York. Followed up with the episode about Jurassic Park. We had a friend of mine who's a lawyer for the city of Philadelphia come in and talk about zoo law. And it's very fun.
Yeah. So I've said this before, but copyright is broader and more pervasive than you think. It is also more practical than you think. It doesn't depend on magic words. So yeah, go forth and podcast. And if you have questions, you can always email me. My email address is very easy. It's mitch@eff.org. If you are looking to be connected with a lawyer to advise you sort of get down in the weeds with you, my organization has a legal referral network. You just want to email info@eff.org.
On social media, you can find me. I'm on Blue Sky primarily nowadays. My handle is mrose.inc, INK. Yeah, there is a Twitter account, but I don't use it. It's just M_F_Rose, which is not intended to be the vulgar version of that. It's just my initials. But it
Happy
works
coincidence.
anyway.
Yes. Happy coincidence. All right. Well, I want to thank you all. You all kind of filled in at the last minute for some folks, and I do appreciate it. I learned some things also, so thank you. And I also want to give a shout out to our track sponsor. The sponsor for this year is Zakat. And for over 22 years, they've been empowering lives through disaster relief, food distribution, orphan care, and more. Their top-notch ratings from Charity Navigator and Better Business Bureau's Wise Giving Fund Alliance means your contributions are going somewhere they're going to make a difference. So, they've been vetted. You can go online at zakat.org. That's ZAKAT.org to donate. We also have QR codes available here at the front of the table. Also, if you're new to Dragon Con, each year we have a different charity. This year, it's the Arthritis Foundation. It's the #1 cause of disability in adults, and it affects nearly 60 million adults. And this was the new thing I just learned, hundreds of thousands of children. So don't think of it as just a senior person's illness. This year, Dragon Con is going to match up to $125,000 of donations. Last year, we raised $272,000 for the charity. I think we might be able to beat that this year. So we have a donation can. Those of you who still carry cash, maybe you got some change, people like me, feel free to drop some in the bucket. Or again, we've got a QR code in the room next door. It's good money for a good cause. Oh yeah, and we got one here too. Oh, perfect. See, technology, it's a wonderful thing. Just buy yourself one less drink tonight and donate what's left to charity.
Be responsible.
Yes,
Donate to the charity.
Ish.
Don't get the mead. Put that money to the charity.
Yes, exactly.
Also, rate the panel.
Yes.
Go on and rate the panel. If you get really good ratings, then they give the track a bigger room the next year.
Yes, exactly. Yes. If you think the moderator was very good and very sexual, feel free to put that. We got the talent, but they do look at that. So look at the ratings. I've been your moderator. I'm Channing Sherman. I am on Twitter and most other social media platforms, just at Channing Sherman. You can hear me on the Dragon Con report leading up to Dragon Con. Digital media, I do a lot of stuff with them because for some reason they've decided to tolerate me over the years. And I have my own podcast, The Smarty Art Brother, which we are bringing back actually after Dragon Con. So please come and listen. And with that, thank you,
Thanks
everyone.
for coming.
Thank you.
Thank you. I do want to get a quick group photo before the show, but yes.